Linda Kelly. I'm the Director of Legal Education Programs here at the Searle Center. The Alien Tort Statute is a one-sentence provision of law that was included in the Judiciary Act of 1789. And what it does is it provides jurisdiction in U.S. federal courts for tort claims brought by aliens, foreign parties, who suffer injury abroad that amounts to a violation of the norms of international law. Examples of violations of norms of international law that were included in the statute specifically were piracy, assaults on ambassadors, and attacks on foreign parties traveling through your lands. Well, what's interesting about the Alien Tort Statute is that it was virtually unused until the 1980s. And from that time, the number and types of cases have grown. Most recently, the Alien Tort Statute has become the basis of claims that are brought against corporations doing business in foreign countries where there are human rights violations occurring. A good current example of a case that has been brought under the Alien Tort Statute that is being battled out in court is a case in the Second Circuit involving a claim against a number of companies that did business in South Africa during the apartheid regime there. And the very simple basis of the claim is that by doing business with the South African government under apartheid, those companies were aiding and abetting the apartheid regime. There are a number of other cases pending involving other issues where basically the foreign government was engaged in some type of human rights violation or unsavory activity, and the allegation here in U.S. court against the defendant is that simply by doing business in that country, the human rights violation was aided or abetted. And this term aiding and abetting is really the crux of the modern Alien Tort Statute, and the issue of whether aiding and abetting liability exists under the statute is being debated in the Second Circuit now. It's probably going to eventually go up to the Supreme Court. The reason that's an important issue is because without aiding and abetting liability, many of the recent and pending claims under the Alien Tort Statute would have no basis because they involve defendants who find themselves in court simply by virtue of having done business with one of these regimes. We plan to commission a number of papers from leading scholars to look at some of the important issues around Alien Tort Statute litigation, and to hold a roundtable discussion here in the spring to hash out all the important issues.